Elijah, so you mentioned about construction defects and that there's a defect in construction, I'm assuming.
Yeah.
My construction's fine. I don't have any defects.
Yeah, a lot of what we see is a lot of mistakes that people make. Even if you did everything right, eventually something may go off, something's wrong. So there's a whole process how this is done. And then you have to distinguish between the work that was done properly and over time it broke, or work that inherently wasn't done right all along because there's a hidden damage.
Who gives the warranty? Is it the installer or is it the manufacturer?
It depends. See, it depends on the issue. Let's take flooring for example. And we
Yes.
had a number of issues, like the actual material failed, so it has nothing to do with installation.
Yeah.
You come over and say, "Well, I'm sorry, ma'am. Yeah, we did the installation. It has nothing to do with installation. It's the claim with the actual flooring." And then the claim is submitted to the manufacturer for replacement and the cost associated with the flooring, and they should cover that. If they don't, that's where the claim, legal claim is addressed to. If you say, well, this is installation, for example, failure to install a moisture barrier, right? The
Yeah.
instruction said yes, and then no one did it, and then the whole flooring warped, then that's an installation issue. You're still liable.
Well, question for you. What if, for example, we installed the flooring, no moisture barrier, but it's like 5 years later?
Because you never installed it right in the first
Okay.
place, so you're still liable.
But let's just say we rented moisture reader. It said it's perfect. Obviously, with time, earth changes, moisture appeared.
Yeah, you follow this. A lot of manufacturers are at fault for this because the instructions for installation say, well, moisture barrier may be installed. No, you have to tell the customer, you have to go through the manufacturer. We're
Okay.
not going to do
So
anything.
they wait for a year,
Yeah.
2, 3, as long as it
It
takes.
doesn't take years for against the manufacturer. You usually get a response right away. Lawsuits take 2-3 years.
Yes.
And that's very short. Bonds take around 4 to 5 months. A bond claim is $25,000. Usually flooring is less than that. So usually the whole bond claim, and that's the first thing that we do. And the bond claim launches an investigation in which they would try to determine is there an obvious defect. If there's a question as to who's at fault and it's not clear, they do not rule. They say, well, we're rejecting your claim. You have to file a lawsuit.
To avoid this whole headache, would it be better to go out to do an inspection first and see whether we did mess up or not, and then just try
And
to
that's
cover
where-
it
yeah,
up?
That's where the lawyer comes in.
Okay.
You say, well, I have a claim, and then the first thing that I ask, I need a signed contract. I need exactly what they signed. I need an invoice, how much it was paid, right? And I need the instructions, installation, everything that you have on that.
And what if no contract? Let's just say I'm an old school.
Old school. Yeah, old school fool, right? Well, no contract is they're still work done.
And they paid me cash.
Baby. Well, if you're coming, again, worldview, what's your worldview?
Yeah.
If your worldview is, let's just collect the money and not do anything, you say,
Yes.
well, I don't know who that is. I never did the work. So unless they have evidence that you actually was there, so they have to prove you were actually an installer.
Like pictures, communication.
Picture communications, yeah. So usually
Okay.
they can do that. Most people can do. And then the contract is established based on the fact, hey, no one usually does flooring for free, so we assume there was an exchange of consideration or money.
Yeah.
By the way, one of the things that you draft in the contract is a warranty provision. You have 1 year warranty, and then even if you do, those are excluded from a warranty. Third-party abuse, misuse, chips larger than, you put like an eighth of an inch, right?
Yeah.
And you put like an entire page of exceptions. So you can give them a warranty.
Lifetime warranty.
Yeah, but no, you never have a lifetime warranty. But you based on exceptions, and that's why you have to analyze the request first. I'm like, I'm sorry, but we know how we installed the floor. We know how we install. We always install the moisture barrier. Has nothing to do with the installation. We had a guy who said, I'm too fat and I broke the floor. He was so fat, it's in an office chair.
Okay.
It essentially cracked the floor.
That's what we're dealing
Yeah.
with right now.
Yeah, and he's like, and then he admitted it failed because I'm fat. I remember we were laughing so much. He called himself fat. And in that case, that's not reasonable use, right? You can lawfully and reasonably reject that claim. And I'm sorry, Bob, what do you expect? I see, well, first off, the extent there is no more warranty. And then even if it wasn't warranty, you abused the floor. That's not how it's supposed to
Yes.
be used. And you say, well, I have no duty at all. You have no warranty. However, let me do this. I can repair it for free, but you sign a release. And that people miss. A release is a waiver. It says, you installed the floors. I found a mistake. You said it's not my mistake. However, I'll repair it for free in exchange for you not suing me in the future for related claims. And there's a section that says, I hereby waive all future claims, even that I don't know of them.
No way.
And then thereafter, you just bought yourself a liability waiver for a very small amount, especially if it's a service, and then the guy thinks he got a deal, but actually he can no longer proceed against you for the same issue, essentially. If it's a different issue, he can go back from against you depending on the issue. So we got him to admit in writing that it was actually his own admission.
Obviously, you spent your time on it. The contractor had to invest his time in it. So contractors, let's just say, now losing about $5,000 in this case. Why?
That's the point, right? Yeah. So again, that's where the balancing. You contact a lawyer, and it looks like, hey, this is just pay him out. This is not worth your time.
Or just ignore the guy.
No. Well, yeah, you can ignore him, but there is a right way to resolve a dispute.
Okay.
Right? The contract, if properly drafted, has an attorney's fee provision. It says if there's a dispute with respect to the services rendered hereby under this agreement, the prevailing party or the party who wins gets paid attorney's fees. So essentially, if there was no case against you and you spent like 10 grand on a lawyer, the homeowner will have to pay for your lawyer.
And would the lawyer be in charge chasing the money, or do I have to chase it as a contractor?
No, you pay the lawyer, and then they pay you.
Okay, so I have to chase them. If they don't want to pay or they can't pay, then...
Correct, yeah. So it's an art. No, it's actually not as bad as you think. I know you're going into, yeah, but it's actually better than you would think with respect to homeowners.
Okay, so I install flooring. And then as I was installing baseboards, I shut the pipe. Water leaked. I didn't know about it at the time of the installation. A couple of days later, homeowner complains that her whole house is flooded from second floor down. I don't have insurance. I don't have any contracts. What should I do about this? And I don't have any cash.
What's your worldview?
Well, I feel bad because I messed up. So I want to help him, but it's
you want to help him. So hey, hey, I'll cover the cost of the entire remediation.
But I don't have money. Because we're talking about $70,000, $80,000.
Yeah, well, it's your responsibility.
Yes.
And you say, well, I can't do it. They file a lawsuit against you.
But I don't have any insurance, nothing. They just like a handyman service.
Well, they may recommend you for criminal prosecution. We had that happen because if you're a handyman, you're not supposed to do flooring.
Yes.
So you may be jailed. But if you had nothing, you could be sued and you can be, you'll have a default. They'll be suing a useless person. It's like suing a homeless person.
Yes.
Yeah, you can win, easily against a homeless person.
It's just there's no money.
There's no money, yeah. You can file for bankruptcy, but then you have bankruptcy, and that makes it challenging for you to get any credit, to do any work, because you filed for bankruptcy, and that's going to be in your history.
Would you say it would be a good idea? Let's just say I messed up, and it's an $80,000 job that I have to cover. Should I get a credit line, cover it, and then little pay it out for personal?
It depends. See, if you say you have no money, you'll not receive a credit line.
But what if I go to the bank and explain to them the situation?
They won't give you money for that. There's no such thing as...
So what should I do in that case?
They submit a claim against your bond, but you have no bond. You're illegal. Yeah, so I think it's going to be criminal prosecution at that point. You're in deep trouble. No one should be doing that.
Okay.
Or pull as many favors as you can to remediate.
Work myself, do as much material.
No, you can't do that. So call in favors to whoever actually does it. You'll owe them until you pay it off, and then be smarter. But you shouldn't be approaching the project without any kind of... this is an extreme scenario.
See, it happens a lot. It just... Because we have insurance, maybe it's not the installer to install himself, but if we go all the way back, the builder has insurance. So even if the installer didn't have insurance,
see, if you're speaking new builds,
yes.
I'm speaking like an existing build.
But then eventually, homeowner moves in there, right? And then the situation happens, and they're like, "Hey, we have a leak. What's going on?"
Yeah.
So even if nobody has a builder, still has the insurance.
See, you're talking different things, right? Because you have a new build under SB 800, you have the statutory protections of a new build, right? When you have regular trades, you typically have 1 year fit and finish warranty for flooring, right? If you're an installer and then there's no one apart from you, you're done. It's just going to be you. So they'll sue you. They won't get anything. And that's why they have to speak to their counsel. And I would advise them, hey, listen, you can file a lawsuit. You can pay me, let's say, a deposit of 10 grand to file a lawsuit. It's going to be a default, congrats, but then that guy won't pay you anything. So do you really want to pay, or just want to get this done and behind you?
Would you, as a homeowner, want to proceed with the case just to put the guy in jail or just ruin his future?
It depends on how vindictive the homeowners are. And plus, you have homeowners insurance, so you submit a claim there. So you try avenues to get that resolved. But no one should be doing that. My overall holistic approach, if you see that you messed up even a little bit, fix it. You'll pay for your lawyer. Next time, you'll be very careful how you do your floors. You'll take pictures before and after. If you see something weird, for example, if you do roofing, you go and inspect inside of the home for existing roof leaks. You take pictures, of what was there, replace the roof. When it rains next time, your roof will be fine. You come over and they'll say, well, see those spots? This is from your leaks. And then now you have to repair the interior of the house because it came from your leak. But then you have pictures as well, actually, if it was from prior. So homeowners will do all sorts of things to get a recovery. For example, I spoke to an individual recently. Tesla installed solar panels. They dropped off the materials at his driveway and it scratched his driveway. He wants to sue Tesla for a scratched driveway. I mean, those cases won't go anywhere. It's too minute. It's a Karen lawsuit, right? It's too small.
Because we actually had that. So a person stepped on the wet concrete accidentally. It wasn't as good, but they literally had to demo out the whole concrete because it was still fresh. They had to let it cure, then demo it completely and re-pour it. There was no way to fix it.
Yeah, it depends on the experts. I'm not an expert. So we would, if there's a defect, we always ask, have a licensed contractor at least look at it and say, well, in my opinion, this is all wrong.
Okay.
And issue a report. And then we base that report, hey, this is how much you owe us. If it's more complicated, we have a construction expert who's licensed. He comes over and then gives an expert report. Hey, listen, this is what was done. This is what wasn't done.
What was the biggest or dumbest mistake that you had to deal with? Let's just say because the person didn't take proper precaution. Did you have any massive cases like that?
There's so many. They're not stupid. They're just equally just foolish. People they come into the business with zero preparation. At least have something. And that's my biggest beef.
Well, you mentioned that if you want to start the legal process, just find an attorney nearby.
Correct,
Business attorney, and they will guide you in terms of what you have and what you don't have. But is there a specific case that can happen where, let's just say you don't have an attorney nearby you, a business attorney? Could there be such a thing?
Well, there are lawyers out there.
Yes.
The lawyers who specialize in construction defects defense. So they're out there. They're not cheap. So the issue is there's no lawyer you can afford.
But can you get a lawyer from a different state that's like a lot cheaper? And let's just say he does a good job, but we're in California. I want to go to Denver.
Well, that's one of the foolish things that you want to do.
Yeah?
Like I receive a demand from a Florida lawyer who represent a client in California. First off, that's partially illegal, but that'll be funny because you can't do anything here in California. I'm like, okay, toss the demand. Well, we scan the demand. I'm like, oh, it's funny. Haha. Let's go to book of shame, right? Cute, right? Nothing is going to happen. So there are always lawyers who can assist you, without a doubt. That's not the issue. It's just what are you going to do with it? But again, I tell people it's hard for homeowners to sue a really nice contractor who doesn't delay with schedules, keeps you informed, very, very upfront and honest. And I think that's the holistic approach that you would take. It's hard to sue that kind of individual. You can say, you know what? Bob, it was me. It was my fault. I admit it. I fixed it. Let me fix it. Would you really sue a person who says, hey, I'm going to make it right. Don't worry about this whole thing. I mean, it's hard to sue a person. Only a really rare person who doesn't really, have any feelings would actually file a lawsuit against that kind of individual. But even then, you have to go through a litigation process.
Is there homeowners that contractors should avoid?
Yes, definitely. That's a very, very good question. If she's a Karen and he's a Ken, avoid them. And then you know them right away. They're very, very picky. Very picky.
Are they cheap as well and picky? Or could you say that they will pay you fair, but they will not leave you alone?
No, they'll pay you. They're not necessarily cheap. They accumulate things against you. If they read a contract before they sign, not saying you shouldn't, but they're obviously reading and they're starting to poking, hey, I don't like this, I don't like this. Oh, limitation of damages, I want that gone. I don't want any limitation on damages, which means if they sue you, they can sue you for unlimited cap. Limitation of damages, one of the things in a contract saying, hey, if you sue me, the maximum you can recover is, for example, the amount you paid me. That's the maximum.
Yes.
You won't pay, I don't like that. That's a bad sign. So, you know what? My lawyer told me, if you question the contract I drafted, I'm not going to work with you. So goodbye. Thank you for working with us. Hopefully you find a contract that works for you. This is the contract. We do not change it. Unless you really want the project, then you go back. Elijah, they want this removed. Do you want the contract? Yes, I do. Let's cut this or adjust.
Is there a problem? Let's just say we got very close to signing the contract and I declined the customer. Is there a problem they can come after me afterwards?
No. Unless you did it for improper reasons. Race, gender, discrimination, and all that stuff.
Well, educate me. I don't know anything about that.
Well, you can't withhold a project because a person is a specific race or a specific gender or a specific ethnic origin or a specific religion. You can't do that. That's illegal. But if it's a business decision, it says, well, it's a contract term, and I'm sorry, I can't agree to your contract term, so we'll have to withdraw.
And how about canceling existing contracts? Let's just say that they want to change something, but they're not willing to pay for it, and now I can't finish the project because there's a change order.
Yeah, it's in the contract, and then it usually permits you to leave. The work you have to pay, you get paid up to that work, and then you can leave, no obligations.
What about the materials that I bought? I bought the materials for the start and the finish.
Yeah, they pay you for the materials. They own
and then
it.
I leave the materials.
Yeah,
with
they
them.
own it.
Okay.
Yeah, you can't take the materials back. Usually, you sign a contract, they put the deposit 10% or $1,000, right? And then you order the materials get delivered, right? As soon as they're delivered, you pay for the materials, or they buy them directly, so it's their cost, or you issue an invoice right away. Because you can't charge in a construction contract for services you haven't otherwise rendered.
Yes.
As soon as you made the cost, submit an invoice, they pay for it. Usually, if you want to terminate, there's called a termination contract.
We did the driveway for the homeowner, and they're not paying for it. I can put a lien. It will take who knows how long. I saw a couple of videos where people literally just went and demoed it as it was fresh. Dumb situations.
Mechanic liens. So you have the construction defects where you did something and it's alleged against you. The other issue is you did the work, you're not getting paid.
Yes.
It's called the mechanics-lien process. Very interesting as well. We handle a number of those issues. So you have 90 days to issue a mechanics-lien, to place a mechanics-lien. So if your contract is properly drafted, it gives you the appropriate notice to put a lien on. If you're a direct contractor, meaning they signed a contract with you, not with the builder, not with the prime contractor, but with you directly, you have 90 days to file a mechanics lien. So essentially, you do the work. After you're done, issue the invoice right away. 30 days later, you follow up. Hey, Bob, you haven't paid me. I'm not going to pay you. You know what, Bob, let's do this. I'm going to give you another 30 days, after which I'm filing a mechanics lien. So the second 30 days is a kind of a grace period. Then I need the other 30 days to actually file a mechanics lien. Mechanics lien is filed on the property, gets noticed, and like, oh crap, file the mechanics lien. After you file a mechanics lien, you have 90 days to perfect the lien. Meaning, the lien is on the house. If you don't do anything, it's going to expire after 90 days.
Okay.
And that's what contractors don't know. And homeowners, some of them know, and they're waiting it out to see if you actually file a lawsuit. We do that all the time. We strategically wait. Let's see if he files a lawsuit. We send a demand to the contractor saying, hey, the mechanics lien expired. You can't have it. You must, by law, remove it now. If you don't, we can file a lawsuit and you will pay for my time for filing a lawsuit. So again, from the contractor standpoint, 30 days, no payment, call them, Bob, sorry, listen, I got to pay my workers. You haven't paid. You have to understand. My lawyer tells me that I have to file a lien now. Let's do this. I'll give you another 4 weeks. Come up with the money. I don't want to file anything, but my lawyer, he's very aggressive. He's a shark, man. Let's get this done. Do you want a discount? Let me give you a quick discount. Knowing that to file a mechanics lien, it costs around $1,000.
Okay.
With services, right? Let me give you $1,000 off, right? Let's get that paid and taken care of. Yeah, okay, and then he pays right away. You just won a case. And then if he doesn't, you put the mechanics lien, you file a lawsuit to foreclose. And then now he's scared. He goes to the lawyer and the lawyer says, no, you messed up. Now you have to pay for his lawyer filing fees for all this to remove that lien.
And let's just say he still doesn't want to pay. What
He goes
happens?
to the court.
Okay.
And then it's going to be dumb because ultimately if you prevail, there will be court ordered to foreclose. The house will be sold, his loan paid off, and then you get paid. That's just a dumb way to go. Usually flooring, those are small claims.
Yes.
They're not large. So they should just usually they borrow, get a loan, do something, and then they just pay you off. Most of them, if not all of them, are settled usually, unless there's a bona fide claim as for a dispute. For example, you did the work. It's like, you messed it up. I'm not going to pay you. Well, I'm going to put a mechanics lien. It happens all the time, by the way. Says, well, I'm going to put a mechanics lien. Go ahead. I'm going to sue you. So you file a lawsuit, and then he files a cross complaint. So meaning you sue him, he sues you. And now both of you are in court. The house stays there with the lien on it until you resolve. And then the lawyers fight, and then we win. Lawyers win, always, because we get paid for our time. And then you try to negotiate. I'm going to set an expert to see, what's actually defective. And then the expert says, well, this is what defective. Well, my expert says this is not defective. And then experts fights too. Lawyers get money. So again, you have to be very careful how you do this. If it's a smaller claim, just pay it off with a release.
Okay. What I understood is you're in a good business.
Yes. Yes.
Elijah, thank you so much. This was super interesting.
Yeah. One thing I would leave your viewers with, if you're in construction, having a lawyer, not necessarily hiring, having a lawyer on standby who knows what your business is, what's your name, everything. It takes like a couple of hours to onboard a case and a documents. You'll know exactly what to do within like a day, usually.
There's a lot of lawyers that have welcoming onboarding. It's like low cost or no cost. Let's just get to know each other, and then for the future, at least we have a connection.
I'm not sure how other lawyers do it. We do an overview meeting, at least an overview. You come in, we sit down, it's a paid consult. We introduce, we talk, I introduce, this is what you need. You know exactly where your low points are. And then thereafter, you're in my system. You just call me, hey, I'm like, okay, let's proceed. That's usually how it's done.
Thank you. I appreciate your time.
Yeah, I'm glad you asked the question, because construction defects and breach of contract from both sides is an important part of what you do. I think it's riskier than, just typical transactional work where you actually install floors.
It's not worth the money, I'm assuming.
It depends.